Tinker versus Des Moines Independent Community School District, an educational program planned and developed by the Historical Society of the District of Columbia Circuit, with video produced by the Federal Judicial Center, December 14, 2017. Nicolas Sansone sets the stage, followed by Robert Niles and Mary Beth Tinker, who discuss the events that led Tinker to the Supreme Court. The featured portion of this program is a reenactment, led by Zayn Siddique, arguing as petitioner Tinker, and Nicolas Sansone, arguing as the respondent school district, with Judges David S. Tatel and Srinivasan of the United States Court of Appeals for the District of Columbia Circuit, and Judge Ketanji Brown-Jackson of the United States District Court for the District of Columbia presiding. A question and answer portion of the program is conducted by Amy Lishinski.
Hello, everybody, and welcome to today's program. We're so glad that you could all be here with us today. Now, just a quick word about today's program. Today, as you probably already know, you're going to see a reenactment of a court case that was originally argued about 50 years ago, back in 1968. So as you know, the law tells us what we can and can't do, but it also tells governmental entities, such as public schools, what they can and can't do. So the case we're looking at today was brought by several students who believed that their school had violated the law, specifically the First Amendment of the United States Constitution, by restricting the students' right to express themselves freely. The students lost in the court where they first filed suit, so they appealed to a higher court, arguing that the first court was wrong. In this second higher court, a group of 8 judges heard the case and split evenly, 4 judges agreeing with the students and 4 judges agreeing with the school. Because there was a tied vote, the first court's ruling in favor of the school board remained in place. So the students asked the Supreme Court, the country's highest court, to hear their case. The Supreme Court agreed to hear the case, and today you're going to be hearing the arguments the lawyers for both sides made when they appeared at the Supreme Court. 3 of our judges will be playing the roles of the Supreme Court justices who heard the case back in 1968. My friend Zayn, over there, and myself, Nick, will be playing the roles of the lawyers. Zayn and I work for one of the judges you will meet later today, as do our 2 friends, Amy and Robert. You'll hear from Amy and Robert today as well. But before we do the reenactment, it's important for you to have some context about what the case is all about and how it ended up at the Supreme Court. So we are very lucky today to have with us Mary Beth Tinker. One of the students who initiated the lawsuit will be studying today. So my friend Robert is going to speak with Mary Beth a little bit about the events that started her on the path to the U.S. Supreme Court. So let's go ahead and welcome them.
Here. Wow, you all look great. What a place and what a program.
So Mary Beth, thanks so much for coming in today.
Oh, it's great to be here with all of these wonderful students, teachers, judges, and you, Robert. Thank you for having me here today.
Thank you. So in a few minutes, we're going to see a reenactment of a Supreme Court case. And that case is called Tinker versus Des Moines.
That's
and
pretty funny right there.
That's you. You are Mary Beth Tinker. So why don't you tell us what exactly you did 50 years ago that got this all started?
I was growing up in mighty times, just like now. Does anybody think we have mighty times going on right now? Yeah, come on, let's hear it. All right. I knew you would. It was mighty times like now. And I saw some kids on TV one day that were so amazing. They were in Birmingham, Alabama. And they were marching and singing songs like, I was singing earlier, "This little light of mine, I'm gonna let it shine." And they were standing up for what? Racial equality, racial justice, right? Yeah. Martin Luther King was in jail already, writing his famous letter from Birmingham jail. But the kids said, "That's okay, Martin, we've got you covered. We're going to march and sing and stand up for justice." And so I saw them on TV, and they were so amazing because the police put dogs on them. And the fire department put fire hoses on. Who's seen these photos? Yeah. The photos went viral all over the world. And they went to our living room up in Iowa where I was growing up, and they inspired us to also speak up and stand up for things that we cared about in democracy, and for love and brotherhood, and those values that we learned in church where my father was a minister. He was a Methodist preacher. Our teachers taught us about democracy, and my father taught us about values, and my mother, and so many others. So in 1965, then we saw the Vietnam War building up, and on TV. It's really a story of journalism, how wonderful journalists are, and bringing us these stories. Otherwise, how would we know what was going on in the world? So in 1965, on the news, we saw the Vietnam War building up, and it was so sad, and there were children that were running from their burning huts in Vietnam, and soldiers lying in body bags. It was really sad. We were already sad about Birmingham, but now we were getting really sad about the Vietnam War. And so we didn't know what to do. It's like a 7th grader told me recently. She said, I see the news and I feel so sad sometimes. I know some of you feel that way. But she said, I don't know what to do. That's how we felt. Some students in Des Moines had an idea. What if we wear black armbands to school to mourn for the dead in Vietnam? Because after the Birmingham kids marched in Birmingham, the Ku Klux Klan did something to punish them. You know the Ku Klux Klan? Yeah, they're terrorists. They're white supremacists. And they're still around. The Ku Klux Klan, to punish the children who marched in Birmingham, put a bomb in their church right on Sunday morning, knowing the kids would be in church. And the bodies of 4 little girls were found in the church. They were about the same age as me and my sisters. They were 11 to 14 years old. And a man named James Baldwin, you know James Baldwin? Yeah, he's a great writer. And a man named Bayard Rustin, they wrote a letter and said, what we should do to mourn for the children who were killed by the Ku Klux Klan, we should wear black armbands. And that's what they had done in 1963 when the girls were killed in Birmingham. By the way, the lawyer that went after the Ku Klux Klan for that just got elected to the Senate in Alabama. Yeah. Wow. History still is with us. It's still with us, all of these things. So anyway, back to the story. In 1965, then, we were getting really sad about the Vietnam War, so some of the kids in Des Moines said, what if we wear black armbands to mourn for the dead in Vietnam? Because we had a memorial service in Des Moines for the little girls. And so that's what we decided to do, but it was just like this. And by the way, the armband is over at the museum. Isn't that crazy? We had no idea this was going to turn out to be such a big deal. But the principals made a rule against armbands. And they said anybody wearing an armband is going to be suspended. Oh, that made me really scared. I was really nervous, and I went off to school, and I was so nervous and everything. And when they sent me down to the principal's office and said, now, Mary Beth, take off that armband, I looked around the office, and I looked at Mrs. Tarman, and I said, okay, here you go. I took off that armband. I was so scared, and I was so nervous. That's when I found out something, Robert. You can make a big difference in the world, even if you're scared, even if you're nervous, even if you don't know it's going to turn out to be a big deal. And Mrs. Tarman said, well, you're going to be suspended for doing that. And I've got my suspension notice in here. I'll have to show it to you later. And she said, yeah, maybe it's here. So Mrs. Tarman said, you're going to be suspended for doing that. Here it is, right here. I found this in a box a few months ago. Always keep your suspension notice, kids. Just never know. Mrs. Tarman sent me home, and I was so scared. The next day, my brother John got suspended, and a boy named Chris Eckhart also got suspended. 5 kids got suspended. And all these mean people started coming out, the haters. And they sent us hate mail like this one. Here's a postcard we got. It says hate. Yeah, the haters. They're out there, right, kids? Yeah, they threatened to bomb our house and things. But a group called the American Civil Liberties Union, they said, we're going to help these kids because that's not right. They should have their rights too. That's the American Civil Liberties Union. That's what they do, the ACLU. And they came and started helping us, and they said, we're going to have to always try to negotiate if there's a disagreement. So we did. And you should do that today, too, if you disagree with something. Try to work it out. So we went to the school board. We tried to change their mind, but they wouldn't change their mind. So we had to, okay, there's 3 branches of government, right? Tell me the 3 branches. Legislative, executive, judicial. Which branch are we at today? Judicial. Thanks, judicial branch. Thanks to the judicial branch, yeah. Where's our judges? Thank you, Thank you, Justice Tatel, and so many others. Okay, so anyway, the ACLU said, we're going to have to go over here to the other branch of government, the judicial. So that's what they did. And they took it to court, and we lost. And we lost at the appeals court. And I thought, of course we're going to lose. No big important judge is going to say kids have rights. But then it was appealed to the Supreme Court, and amazingly, by this time, when we started, I was in 8th grade. Who's in 8th grade? Got any 8th grade? Yeah, just like you all. When I started, I was in 8th grade. Then, by the time we won, I was in 11th grade, and I couldn't believe the Supreme Court, with people like Abe Fortas, William Brennan, Thurgood Marshall, Justice White, voting that actually students do have rights in the public schools, and when students enter the gate of the public school, they do not lose their rights, and neither do teachers. And they said one of my favorite things in the ruling, which is that students are persons. Yeah, that's kind of good, right? You like that, guys? Come on, let's hear it. All right, you are persons with rights and responsibilities of persons, and they said there are 2 things you cannot do in the public schools. Number 1, disrupt school, substantially disrupt school. They said that's still not allowed. Yes, you have your right to free speech, cannot substantially disrupt, and cannot impinge on the rights of others, whatever that means. And that's been debated ever since, probably why this ruling has been cited over 6,000 times, the last time I checked, in student speech cases. So I'm a nurse. I went on in my life. I had no idea that this was going to be such a big deal. I became a nurse. I work mostly with kids. I was working last at Prince George's Hospital with teenagers. Yeah, who's from Prince George's? Yeah, all right, Prince George's. And I said, you know what, a few years ago, I said, I'm going to leave the hospital, and I'm going to start traveling around and talking to kids about their rights and how they should stand up for their rights, because I said kids aren't getting a good deal in our society. Like right now, I have a red ribbon that I'm wearing that was given to me over at American University by some teenagers a couple of weeks ago. Yeah, where's the Students from School Without Walls? Yeah, thank you. Thank you for coming, and thank you for giving me the ribbon. This is to honor Yuseli, who was a student at Cap City Charter School, and he was killed about a month or so ago. And I'm mourning right now today also for a student at Wilson High School, Jamari, who was killed last summer by gun violence. Students are standing up about all of these things, and about racial justice, and about peace, and about the environment, and about school lunches. I know you all want, but you said you wanted school lunches. That's what you all are standing up about. And so many things. I listened to students all over the country who are speaking up and standing up and using their First Amendment rights. So that's what happened, Robert, and that's what brought me here today. And thank you for having me here today. Thank you to all of you.
I think we're good. Thank you. And now we're going to move on to the reenactment. Thank you, Mary Beth.
Okay, thanks a lot, Robert.
Thank you, Mary Beth, and thank you, Robert. So later in the program, you'll have the opportunity to ask Mary Beth any questions you might have about her experience. For now, though, now that you know a little bit about the nature of the conflict between the students and the school district, we're ready to present you with the actual arguments that took place at the Supreme Court in Mary Beth's case. We've trimmed it down a little bit somewhat for the sake of time. To participate in our reenactment, we have 3 federal judges joining us, Judge Tatel, Judge Srinivasan, and Judge Jackson. To become judges, all 3 of them were selected by the president and approved by the Senate, so they're very well-respected people, and we're very lucky to have them with us today. So just a couple words about each of them. Judge Tatel was appointed to the D.C. Circuit Court of Appeals, that's the federal appeals court, by President Bill Clinton in 1994. Before becoming a judge, he worked at a law firm, a number of nonprofit organizations, and the government, and he focused most heavily on education issues and civil rights. Judge Srinivasan was appointed to the same court, the D.C. Circuit, by President Obama in 2013. Before becoming a judge, he worked for law firms and the government, and in these roles, he argued 25 cases before the Supreme Court. And Judge Jackson was appointed to the District Court for D.C., that's the federal trial court here in D.C., by President Obama in 2013. Before becoming a judge, she worked for both law firms and for the government, and she served on the United States Sentencing Commission, which is a body that gives guidance to judges on how much they should punish people for certain crimes. So later in the program, we'll have time for you to ask the judges any questions you have for them. But for now, let's turn to the mock oral argument for Tinker versus Des Moines. As you listen, I want you to notice how the judges are trying to figure out what rules should apply in the schools when it comes to freedom of speech and expression. And after the arguments, my friend Amy will be asking you some questions about what you think the rules ought to be. So with that, I'm going to turn this over to Bryant, one of our marshals, who's going to call the courtroom to order.
All rise. All those having business before the Honorable David S. Tatel and the Honorable Srinivasan, Circuit Judges of the United States Court of Appeals in and for the District of Columbia, and the Honorable Ketanji B. Jackson, Judge of the United States District Court in and for the District of Columbia, now are hearing the proceedings of Tinker versus Des Moines Independent Community School District will draw nigh and give their attention. God save the United States of America and this honorable court. Please be seated. This honorable court is now in session.
Morning. We'll begin by hearing from petitioner, Mr. Siddique.
Mr. Chief Justice, and may it please the court, this case is here on appeal from the United States Circuit Court of Appeals for the 8th Circuit. The case involves the right of public school students to express their opinions in a non-disruptive way while they're in school.
Who are the students filing this suit?
There are three: Christopher Eckhart, who is 16 and in the 10th grade, John Tinker, who is 15 and in the 11th grade, and Mary Beth Tinker, who is 13 and in the 8th grade.
And what happened to these three students?
These students decided that, in spite of their school's announced ban on wearing armbands for this purpose, they would wear them as a matter of conscience. In accordance with the policy, each was then suspended. But as you can see from the evidence, none caused any disruption at school. We therefore believe that the school's enforcement of the armband policy violated their First Amendment rights of free speech and expression.
Counsel, what if a student got up in class and delivered a short speech about the Vietnam War? Then could the student suspend the student? Then could the school suspend the student?
In that case, Your Honor, we would be talking about a very different situation. While that student would still be expressing his views, he would also be causing a disruption.
Why do you say there wasn't a disruption here? Didn't the students wear the armbands so that the other students and teachers would look at the armbands during class time?
The purpose of the armbands was for others to see them, Your Honor, but in a way that would not be distracting.
But how is that not distracting? The students were studying English or math, and then they're also supposed to be thinking about the Vietnam War, according to Ms. Tinker. Isn't that going to be a distraction to the students?
No, I don't think so. I believe that the method the students chose was designed in a way that it would not cause any kind of disruption.
So it was an ineffective message, and the students intended it to be ineffective.
No, Your Honor, they certainly intended their message to be effective, but they sought to convey it in a way that would not distract other students for more than a few minutes, just as many other things do in the classroom, which are allowed from time to time.
Counsel, it can't be that the students were simply trying to stop the students from being disruptive while in class. The schools prohibited the students in the prohibited students in the cafeteria, in the halls. They prohibited the students from wearing the armbands at any time in the school, right?
Yes, that's right.
Let me ask you this. What if, instead of armbands, the students wore big buttons on their shirts that said, "Stop the bombing in Vietnam"?
I think the school could not ban that either because the buttons wouldn't be distracting. As a matter of fact, students in Des Moines schools wore a number of political buttons, some supporting different presidential candidates.
Counsel, under your view, then, this policy wasn't really about preventing distractions because the school allowed students to do other things like wear political buttons that would be distracting in the same way that the armbands were. Am I summarizing your view correctly?
Yes, exactly, Your Honor. The policy was directed at one specific kind of conduct, wearing black armbands, when there were so many other things students were doing that were very similar, such as wearing buttons that said, "Vote Nixon," and things like that. The school didn't attempt to ban any of those other things. The school simply singled out this one type of conduct without any reason.
Well, would it be okay then if the school said no political messages by the students? No buttons, no signs, no armbands? What if they did that?
We still think that would not be allowed because the school would be banning speech that is not disruptive.
Well, what if the school had a policy that said no political messages in class? Let's say the students were allowed to wear the armbands at lunch and in the hallways, but not in class.
Your Honor, I don't think the Constitution allows that policy either. In my view, the Constitution requires that students be allowed to express themselves, even in classrooms, as long as they are not disruptive.
Well, what would qualify as being disruptive in the classroom? If you don't think wearing an armband or a button is disruptive, then what would be?
I think you'd have to look at it on a case-by-case basis. But generally, the student's conduct would have to do more than simply get other students to look away from their teacher for a brief moment.
Well, what if a student wore a T-shirt with a very provocative message on it that might make some students sad or angry and cause them to lose focus for 5 to 10 minutes in class? Would that be enough of a distraction for a school to ban the T-shirt?
Again, I think it would depend on the circumstances. As I said before, there are many things that distract students in class. A message that distracts a few students' attention for a few minutes hardly seems disruptive.
Counsel, I suppose you would concede that if the armband started fistfights or something of that nature, a principal could prohibit students from wearing them?
Your Honor, I'm hesitant to explore that possibility because it's a very different case from the one here. There is no evidence in this case that the armbands caused any...
Counsel, I know what the evidence is here. I'm asking you a hypothetical question. I don't see why it's so hard for you to give an answer. If a student wears a shirt or button or something that causes fistfights, it's clearly disruptive. Schools can ban whatever item caused a fight, right?
I'm sorry, Your Honor. I think in that case, the school could probably ban whatever item caused the fight.
Did you say probably?
I'm hesitant, Your Honor, because I can imagine a situation where a student wants to wear a shirt with a relatively harmless message, but another student overreacts and starts a fight. I don't think the Constitution allows schools to ban relatively harmless messages simply because another student doesn't like the message, but that's certainly an exception. Generally, you're right, that if a message causes fistfights, a school should be able to ban it.
But something can also be disruptive without actually causing fighting or violence, correct?
Yes, of course.
For example, students shouting in class would be disruptive, even if it didn't cause any fighting, correct?
There isn't any doubt about that, Your Honor.
And it wouldn't have to make anybody mad or anything, right? It could even be a very funny comment that made all the students laugh.
Anything that prevented the school from carrying out its normal activities would be disruptive.
Well, is there any evidence of that here?
Your Honor, there is none. There was a discussion about Vietnam in the cafeteria at lunch. There was some discussion in the halls. John Tinker wore the armband in the first hour of class, which was a free discussion type of class. The teacher was outside of the classroom, when some students asked Mr. Tinker about the armband, and he told the other students why he was wearing it.
If the evidence showed that the wearing of the armbands significantly or substantially or materially, whatever's the right word, interfered with the business of the classroom, then you would say that disciplinary action would be justified, correct?
Yes, Your Honor. I do want to make a distinction, though, as I said before, between the expression of a message that is itself disruptive, for example, yelling in class, and the expression of a message that might cause someone else to disrupt the class. I think we'd have to look at how provocative the message actually was and ask whether it was the fault of the student making the message or the student reacting. But we don't have to answer that question here because this case is much easier. There was no disruption at all, so the school clearly could not punish students for wearing the armbands.
Doesn't this case require the Supreme Court of the United States to get pretty deep in the weeds of day-to-day school activities? Shouldn't we just leave these matters to school boards, who are the experts when it comes to running schools?
I agree that school boards have a difficult task when trying to address these issues. But school boards cannot violate the First Amendment, and this court must ensure that they do not violate the First Amendment.
Does your proposed rule apply to kindergarten too? Kindergartners can also express themselves as long as they aren't disruptive?
Well, to the extent, Your Honor, that kindergartners have views and can express them, I think the same rule would apply. I don't think there should be a special rule for kindergartners. It might be the case that it would be easier to disrupt younger children, so the types of messages a student could make would be more limited. But if there's no disruption, then the students should be able to express themselves. If I may, Mr. Chief Justice, I would like to reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from respondent. Mr. Sansone?
Mr. Chief Justice and Associate Justices, we believe that there are two basic questions in this case. First, must schools wait until violence and disorder occur before they act, or can they act when they reasonably and in good faith believe that student expression will lead to disruption? Second, does this court want to have to review every decision of every school district made in good faith and in school administrators' reasonable judgment?
Counsel, how many students were involved here?
7 wore armbands, Your Honor.
7 out of 18,000 students in the Des Moines School District, and the school board was afraid that those 7 students wearing armbands would disrupt 18,000?
Well, I think if the court would...
Am I correct?
That doesn't give us the entire background about the environment in Des Moines, Iowa schools at the time the armbands were worn. As we view it, the right to freedom of speech on school premises must be weighed against the right of the school administrators to exercise reasonable judgment to avoid disruptions in schools.
Petitioner's counsel just told us that there was no disruption.
Well, Your Honor, although the school board didn't point it out, one of the students did say when he was interviewed that 2 boys wearing armbands were punched.
Is that unusual? How many boys are normally punched each day in the Des Moines school system?
I couldn't say that, Your Honor, but I think that gets back to the first issue I brought up. If a community is upset and divided about an issue and students want to express their views, does the school district have to wait until there is a disruption, or should it be allowed to take steps to prevent disruptions?
Was the atmosphere in the community tense?
Yes, Your Honor. There had been marches in Washington protesting the Vietnam War. Many young men across the country had burned their draft cards. The armband situation was in the local newspapers, and 200 people attended the meeting where the school board decided to ban the armbands.
What if there was the same sort of commotion in the community, but instead of wearing black armbands, the students wanted to wear black ties in order to mourn the fallen soldiers in Vietnam?
I think, Your Honor, that your question gets back to the difficulty that I discussed in my opening. It's difficult to sit here in this court and make these decisions for schools. Maybe the black ties would present the same problem, and maybe they wouldn't. We should leave that up to the schools to determine.
Weren't the same debates about the Vietnam War happening across the country? Is it your position that if there's a controversy about an issue across the country, students no longer have First Amendment rights to express their views about that issue?
Well, free discussion in the classroom is always permitted. But when school administrators believe that an action might disrupt the orderly conduct of schools, that's another situation. Students cannot express themselves at every time, in every place, and under any circumstances. The petitioners argue that school officials are powerless to act until a disruption occurs. We do not believe that should be the rule. Sometimes you must act to prevent a bad thing from happening.
On that theory, counsel, could school administrators ban all discussion or demonstrations about political matters or political candidates or issues of government?
Not at all.
Could they ban it in the school?
Not at all. But they could set rules regarding when and where the students could discuss those issues.
Suppose there's a community that finds a particular candidate for president highly controversial. Could the school ban buttons that show that candidate's picture?
Well, if the situation were explosive, like in this community, I think they could.
Well, now, what evidence is there of explosiveness in this community? That's the thing that I haven't gotten out of this yet.
Well, I'd refer first to the John Tinker situation. He said that at first, no one saw his armband, but after gym class, some of the students were making fun of him for wearing it. Other students, his friends even, made remarks that were not very friendly. One student was making sarcastic remarks for about 10 minutes.
Sarcastic remarks? You think that schools are allowed to ban student speech if it leads to some sarcastic remarks? Have you ever been in a middle school? Do you have any evidence at all of disruption?
Well, Your Honor, I'd like to point out that the record does contain some.
How about you answer the question I just asked you?
I don't think that there has to be a disruption. In my view, there only has to be a danger of disruption.
Was there a danger of disruption?
I think so, Your Honor. But I don't think the test should be whether you or I think the evidence shows there was a danger of disruption. It should be whether school administrators reasonably believed that there was a danger of disruption.
But we must still determine whether their actions were reasonable based on the evidence, right?
Yes, of course.
What is the evidence suggesting it was reasonable here?
There is testimony from Mr. Tinker that some of the boys were subjected to physical violence because they wore armbands.
The school district, though, counsel, never pointed to any evidence of violence in defending its decision. If the school board knew about it, wouldn't they put in evidence about it?
That would sound reasonable, Your Honor, yes.
Do we have anything more than just your assertion that the administrators reasonably believed there was a danger of disruption?
I think, as I've stated before, Your Honor, that it was a matter of the explosive situation that existed in the Des Moines schools at the time the armband policy was adopted.
Besides the march in Washington, what's the evidence of this explosive situation?
A former student of one of our high schools had been killed in Vietnam. Some of his friends are still in the school. It was felt that if there was any kind of demonstration about the war, it might evolve into something very difficult to control.
Do we have a city in this country that hasn't had someone killed in Vietnam?
No, I don't think so, Your Honor. But I don't think it would be an explosive situation in most cases. But here, where someone's going to wear an armband, it could be.
Your position is that it could be explosive?
Yes, sir, it could be.
It could be, but according to you, the rule should be that as long as there could possibly be a disruption, the school can ban the expression.
Well, Your Honor, I don't think it would be proper to ban armbands or other expression if a school administrator had an unreasonable fear of disruption.
Do you believe that the Constitution guarantees students the right to discuss political events in school?
No, I don't believe the Constitution guarantees that right, Your Honor. I think if the political discussion broke down the discipline of the school could ban it.
So what you're saying is that the school district has a right to run the school for the teaching of geometry and history and math and grammar and the things that people want to teach, and that the federal Constitution doesn't step in and tell you you've got to let anybody discuss any subject they want to.
We think students can discuss things, but not if it interrupts or disrupts the atmosphere in the school.
So you think the Constitution allows schools to ban discussion of particularly emotional subjects, like the Vietnam War, right?
Yes, Your Honor. We think that given the atmosphere surrounding this issue, the school administration and the school board acted reasonably. Of course, it could be very different at another time. Maybe sometime in the future, discussion of Vietnam wouldn't be an explosive topic and there would be no concern about disruption.
But even if it isn't explosive, students shouldn't be able to interrupt a history class or a math class simply because they want to talk about Vietnam or some other topic, right?
That's right. I believe we have schools to give these children an education, and anything that threatens the scholarly atmosphere of the classroom ought to be prohibited.
Was there a disruption here?
Well, they spent the whole math period discussing Vietnam, and what was supposed to be taught was math, so I think that's a sufficient disruption. The schools ought to be able to ban students from taking over the class like that.
So what courts are supposed to do, counsel, is figure out whether the schools acted responsibly or unreasonably, and based on that, decide whether the students' First Amendment rights were violated?
I think that if the courts have to start looking at every school rule, then it becomes very difficult.
Well, I agree with you. This is difficult.
That is why we suggest that the court give school administrators a lot of room to decide how to balance student expression against the school's need to provide an appropriate educational setting. If courts do not respect school administrators' decisions, then courts will end up examining all sorts of disagreements between students and school administrators.
Thank you, counsel. We'll hear a rebuttal from petitioner, Mr. Siddique.
Opposing counsel indicates that there was some sort of explosive situation which made this a special circumstance. I can just simply say that I don't believe there's any evidence showing an explosive situation.
Hold on, these students broke a valid rule. Isn't that enough to be explosive?
Your Honor, our point is that they broke an invalid rule because it banned student expression that was not disruptive to the school environment.
But doesn't the school system and the teachers have a right to run the school and establish the rules for teaching?
Your Honor, they do, but they simply cannot violate the First Amendment. The First Amendment gives students a right of expression.
So who do you think has the right to control the school? The students or the teachers and the school board?
The authorities that are running the schools, of course, Your Honor, but even though they have that authority is limited by the Constitution. They cannot violate the Constitution when they set school policies, and in our view, they have done so here.
Thank you, counsel. The case is submitted.
My friend Amy here is going to have a quick word with you guys about what you just saw.
All right, so can you guys hear me? Okay, great. So the judges are going to deliberate for about 10 minutes, and so while they're doing that, we're going to talk about the case and kind of make up our own minds about what we think the rule should be. So let's just start at the very beginning. I know you guys have handouts that are going to give you the answer to this, but does anybody know the source of your right to free speech? You can raise your hand. Yeah. The First Amendment of the U.S. Constitution. Yes, that's exactly right. So you guys have the full text of the amendment in front of you. It's pretty long. It has a few different things in it. It talks about religion and speech and journalism, and there's a lot of really important rights packed into there. But we're going to focus on the part that says, I'm going to quote it, "Congress shall make no law abridging the freedom of speech." And so once we know that abridge means to reduce or limit, then that rule seems really simple. The government may not interfere with your right or my right to speak freely. But in different contexts, that actually turns out to be really tricky. And so that's what judges have to decide all the time. So let's talk through some cases here. So let's say it's 2 o'clock in the morning you're asleep, and I show up outside your house with a huge megaphone, and I'm just yelling into it. And I'm not yelling nice things, right? I'm yelling really mean, horrible things into my megaphone right outside your window at 2 o'clock in the morning. Raise your hand if you think the police can arrest me. Raise your hand, put your hand, okay, and then now raise your hand if you think, nope, that's my right to free speech. I can yell things into a megaphone outside your window all day long. Okay, cool. So this is the kind of thing that courts have to decide. People come to court, they disagree about a rule that seems simple, freedom of speech, and the judges have to decide, okay, does freedom of speech mean that Amy can yell at a megaphone outside of your window at 2 a.m. or not? And so this case, the Tinker case, which Mary Beth told us about, had to do with students wearing black armbands in school. And even though that's not speech like talking, what you wear and how you express yourself counts as speech under the Constitution. And so that's a question unto itself that judges had to decide, but we're gonna bracket that one. And so the judges had to decide, could these students wear these black armbands to school, or did the school have the right to say, no, you can't do that? So we're gonna kind of talk through this. So by a show of hands, raise your hand if you believe that students do not have the right to freedom of speech in school. May not speak in school, or the school can ban things. It's okay, there's not a wrong answer, this is just your opinion. Okay, not very many. It's so surprising. Students, you guys think you have a right to freedom of speech. Let's see. You had your hand up, right? Okay, do you think that there's anything that the school can't prohibit, any speech that you have a right to say in school?
Sorry, can you ask that one more time?
So do you think there's anything the school can't prohibit you from saying?
I think that a school is there for you to learn. It's there for you to take math, history, and literature, all of those classes. What you have to take into account there is that there are certain discussions that can and can't be had. And there's no reason to believe that restricting that, as was mentioned in the case, by saying, well, you can speak about it at lunch, is in any way restricting your freedom of speech, because the option is still there. But you have to take into account that the goals of the school are the very same goals that you signed up for.
Mm-hmm. Yeah. So do you think that that goes as far as like if like with Mary Beth's like armband, like do you think that students can wear expressive clothing in school?
Oh, sorry, Ms. Tinker, but in this case, I'm playing devil's advocate for what it's worth, but I'm going to say no. Anything that can be shown to be disruptive by any reasonable person should not be allowed. It is for this same reason that, for example, you're not allowed to bring a knife into school, because there's a reasonable chance that you might stab somebody. If they have reasonable suspicion and probable cause that something like this will start a fight, endanger other students, or even cause major controversy, then they should have the right to stop it.
Cool, thank you so much. So this is kind of one side, and I think you guys kind of saw this in the oral argument from Judge Jackson, sort of this side that that you should be able, the school needs to control what's going on, the school needs to educate, and to do that we need to like have lots of restrictions, lots of rules, and students can't just be speaking freely. So now let's hear from the other side. Can I see hands? I think I'm going to see a lot. Can I see hands from all the students who do think that you have a right to freedom of speech in school? Just raise them high. Okay, keep them up. Okay, so everybody who has your hands up, you believe that there's at least some things that your school cannot punish you for saying. So let's talk about disruption. Keep your hand up if you think that students' right to free speech is unlimited. The school can't impose any limits. You guys all put your hands down. Hands up if you believe in free speech in school. And keep them up if you think that the school can't impose limits on when or where you can speak. Okay, so can I hear from one of you who wants to speak? Ah, right here. What's your name?
Oh, my name is Donna, and I go to school at Walter Francis Stevens.
Okay, great. Thank you so much. So let's say you're in class. What's your favorite class?
Math.
Math? Okay. So you're in math, and somebody stands up, maybe your friend here stands up in the middle of class, and she just goes on a rant about how much she loves Taylor Swift's new album. She's offended by that. Do you think that your teacher can tell her to sit down and be quiet?
Yeah.
Okay, so you do think, then maybe you do think there are some limits on students' free speech in school?
I feel like if it's disrespectful or inappropriate in any way that it could harm or offend any other, then it should not be said.
Okay, so is it just because it was Taylor Swift? She could talk about a different band?
No, if we're in like the middle of class or like we're in the middle of solving a problem, she just jumps up out of nowhere. Like that's rude and disrespectful because now you're disrupting learning. So therefore others can't catch on to what they have to catch on to because you want to talk about an album.
That's great. Yeah, so you can kind of see how there's a parallel between the two views that we've heard expressed so far. You're both concerned about making sure that you're able to, that the school is able to control the class and allow learning to go forward. And it's kind of about where we're going to draw the line. Do we say, okay, we've got to have learning, we've got to teach math, so like no student speech at all, or is there like some room for student speech? So can you give me an example of student speech that you think that the school can't prohibit?
For instance, if you was to wear a button just to say, or religious beliefs, say I love Jesus or I'm all for Jesus or something, that's a religious belief. So therefore, not everybody is Christian or believe that faith. So therefore, there has to be a boundary set that you cannot cross that line or you cannot expose or express that.
So you think you can or cannot wear the badge that says I love
You can't.
Jesus? You can't?
But if you were wearing, for her, if you were wearing the armband, there's nothing that significant that it don't have no words, it's nothing, it's just there. If you were selling it or something to others, that's disruptive.
So what if you were wearing the badge that said stop the bombing in Vietnam?
You shouldn't be able to ban that.
You should be able to wear that, even though it has words, because it's not about religion. So you think there's something about religion in school. That's really interesting. We have a hand up over here. Can I hear from, actually, there's lots of hands, this is exciting. Can I hear from Ms. Blue Jacket? I'd like your real name, actually.
School Without Walls, and I had a question about the when they were talking about how the armbands led to a fight. I was kind of confused because I think that they still didn't end up like defining what was disruptive, because there's bullying, like they said, like happens all over, and it can be about things that you can't really change. So I don't get how the armbands were something that they could decide is like the factor, because when anything could start a fight and anything could be disruptive, and it's more about like the other person. So I was a little confused.
Yeah,
about
this is a really good point. So I think what you're getting at, and I think it's an excellent point, is the difference between something that's disruptive in itself. So if I get up in the middle of class and I'm talking about Taylor Swift's new album, that's disruptive no matter how everybody else in the class reacts. But if I'm just wearing a black armband, that doesn't have to disrupt class. If somebody else decides they're gonna like try to fight me or bully me about it, maybe they're the one being disruptive. So I think that's a really good point. When we're thinking about whether or not something's disruptive, we might want to think about, is the thing itself disruptive, or are other students reacting in impermissible ways? And maybe that's the problem. I think that's a really excellent point. Okay, so I think we actually have a little bit more time. I do not have more time, so I'm being told no. So now the judges are going to come back in and read the opinion so you can see how the case turned out.
Please be seated and come to order. This honorable court is now in session.
Justice Srinivasan will read the opinion for the court in Tinker versus Des Moines.
I'll announce the judgment of the court. I'm joined by Justice Tatel. Justice Jackson dissents and will read her dissent when I'm finished. First Amendment rights, applied in the light of the special circumstances of the school environment, are available to teachers and students. It almost seems like you have a special involvement in this case. No worries. It can hardly be argued that students or teachers shed their constitutional right to freedom of speech or expression at the schoolhouse gate. We have previously determined that under the First Amendment, a student in public school may not be forced to salute the flag. We explained when making that decision that although school boards have important, delicate, and highly discretionary functions, They may not perform those functions in violation of the Constitution. We must carefully protect the constitutional freedoms of the individual so that we do not strangle the free mind and teach youth to discount the important principles of our government. On the other hand, this court has repeatedly emphasized the need for affirming the authority of the states and of school officials to control student conduct as long as they act consistently with the Constitution. This case thus presents a tension between the First Amendment rights of students and the rights of school authorities to control these students' behavior. In this case, school officials banned and sought to punish these students for a silent expression of opinion, unaccompanied by any disorder or disturbance on the part of the students. There's no evidence here that the students interfered with the school's work or violated the rights of other students to be secure and to be let alone. Accordingly, this case does not concern speech or action that intrudes upon the work of the school or the rights of other students. Only a few of the 18,000 students in the school system wore the black armbands. Only 5 students were suspended for wearing them. Outside the classrooms, a few students made hostile remarks to the children wearing armbands, but there were no threats or acts of violence on school premises. The district court concluded that the action of the school authorities was reasonable because they feared that the armbands would be disruptive. But in our country, vague fears about disruptions are not enough to overcome the right to freedom of speech and expression. Any word spoken in class, in the lunchroom, or on school grounds that expresses disagreement with the views of another person may start an argument or cause a disruption. But our Constitution says we must take this risk, and our history says that it is this sort of hazardous freedom, this kind of openness, that's the basis of our national strength and of the independence and vigor of Americans who grow up and live in this relatively permissive, often argumentative society. In our country, public school officials do not possess absolute authority over their students. Students, both when they're in school and when they're out of school, are persons under our Constitution. They have rights which the government must respect. In our country, students may not be forced to express only those views that are officially approved by school administrators. Unless the school shows that there are valid reasons to restrict student speech, students are entitled to express their views. Because the school failed to do that here, the school's ban was unlawful and violated the students' First Amendment rights. We accordingly reverse the lower court's decision.
Justice Jackson, would you like to read your dissent?
Thank you, Mr. Chief Justice. I disagree with my 2 colleagues because I believe that the Constitution allows schools to ban the armbands. I therefore dissent. While I have always believed that under the First Amendment, a state cannot censor the content of speech, I've never believed that the First Amendment protects a person's right to give speeches or engage in demonstrations wherever and whenever he or she pleases. While the evidence does not show that any of the students wearing armbands shouted, used profane language, or were violent in any manner, their armbands led to comments, warnings by other students, the poking of fun at them, and a warning by an older football player that other non-protesting students had better let them alone. There is also evidence that a math teacher had his lesson practically wrecked because of disputes with Mary Beth Tinker over her armband. Even skimming the evidence, it is clear that the armbands diverted students' attention from their lessons. While the absence of profanity or loud and wild disorder perhaps justifies Justice Srinivasan's statements that the students wearing armbands did not actually disrupt the classwork, I think the evidence overwhelmingly shows that the armbands did exactly what the school officials and principals thought they would do. That is, the armbands took the students' minds off their classwork and diverted them to thoughts about highly emotional subjects of the Vietnam War. And I repeat that if the time has come when students in public schools, kindergartens, elementary schools, or high schools can defy orders of school officials to keep their minds on their own schoolwork, It is the beginning of a new revolutionary era of lawlessness in this country. In my view, students are not sent to school with taxpayer dollars in order to broadcast political or other views. The original idea of school was that children had not yet reached a point of experience and wisdom to teach their elders. It may be the case that the nation has outgrown the old-fashioned slogan that children are to be seen and not heard. But one may, I still hope, still be allowed to think that taxpayers send children to school because they need to learn, not teach. We cannot close our eyes to the fact that some of the country's greatest problems are crimes committed by the youth. Many of them are school-aged. School discipline, like parental discipline, is an important part of training our children to be good citizens, to be better citizens. Here, a very small number of students have refused to obey a school order designed to give students who want to learn the opportunity to do so. One does not need special powers to see that after today's decision, some students in Iowa schools and in schools across the country will be ready, able, and willing to defy practically all of their teachers' orders. Accordingly, I dissent.
Thank you both. Well, the three of us are happy to answer any of your questions, but before we turn to that, I want to just first of all welcome all of the students here to our courtroom. Both the district court and the Court of Appeals use this courtroom, and you're sitting in a courtroom where some of the nation's greatest and most important trials have occurred in the past 50 years. And although what you saw today was a mock court, this is a public courtroom, and we invite all of you to come hear what we do in reality anytime you would like. It's a great show. Now, the case you just heard, it was decided 50 years ago by the Supreme Court, almost 50 years ago, but it's not just history. The decision in this case governs how students and school officials deal with expression in schools today. In other words, if any of you are interested in demonstrating in your schools, for whatever reason, either because you object to some governmental policy or the food in the cafeteria, whatever it is, how and under what circumstances you can demonstrate is determined by this almost 50-year-old decision. So it continues to be extremely important. And we are happy to answer any questions you would like. Zayn, do you want to call on people? When you raise your hands, would you please say your name and what school you're from?
So I'll call on people. I'd also like to mention if you have any questions for Mary Beth as well,
Right.
And feel free to go up and join the judges at the bench, and so you can direct your questions to any of the judges or to Mary Beth, who is there on the ground.
My name is Satia, and I go to school with at Wells at Francis Stevens. And so a student in my school was expressing her sexuality by holding up a pride flag, and she was told to put the flag away because a homosexual staff at our school was offended by it. Do you think that that was against her First Amendment rights?
I mean, it's very, go ahead. I was just going to say it's very hard for us to evaluate specific circumstances without knowing all of the facts in the situation. It's also hard for us to comment as current judges about the law in a hypothetical way, in this way. So I guess my answer would be, I don't know. Judge Tatel?
Well, I mean, we'll think about how the court would think about that question from what you just heard. I mean, what as you heard from both Justice Srinivasan's opinion for the court and the questions that we were asking. The basic question that anyone would have to answer is this. The student you're talking about certainly has a right to express herself, but she can't do it in a way that disrupts the school or disrupts the educational process. And that's why Judge Jackson was saying it sort of depends on the circumstances, because we would have to know a whole lot more about what the consequences in the school without walls were of what she did. Depends on the circumstances.
Yeah, and part of it would turn, for example, so there's a case that came after the Tinker case that was a more recent case called Morse versus Frederick, I think. And it had to do with a situation in which a student demonstrated and with a banner that said, bong hits for Jesus. And that case went all the way to the Supreme Court. And the way the Supreme Court resolved that case is it said that that was a situation in which school officials reasonably thought the banner promoted illegal drug use. And if it's reasonably thought to promote illegal drug use, then that's something that school officials can take action against. And in the opinion, it specifically draws a distinction between that and political speech. And so you have to sort of think about what are some of the data points that inform how a court's going to look at it. What's the nature of the speech? Is it political speech, or is it something else like the court perceived was at issue in the Morse case? And what's the justification that the school gives for restricting the speech? Is it because they're worried that people will react to the speech in a way that's going to stimulate debate? Well, then the Supreme Court in Tinker thought that that was the kind of thing that maybe school officials can't do, that they have to allow the speech. Or are they worried that it's going to, for example, in Morse, promote illegal drug use? That's something that the Supreme Court thought school officials could take action to countermand. So it depends on what's the nature of the speech, what's the justification given by the school and school officials in reaction to the speech, and how do those things balance?
I go to school without walls. So most specifically in this case about the Tinker case, because they wore the armbands and there was no violence involved, then that prevented the school from banning it. But I have a similar analogy. So let's say if someone is wearing a shirt and it's about transgenders and that causes violence, but nowhere in the Constitution does it protect transgenders or your sexual orientation, including gays. And I want to talk about a case because I know that freedom of speech is very subjective, whether you're expressing yourself through your freedom of speech or whether you want to restrict others from your freedom of speech. And I know that you have a background on the case and you know about the case, so I want to ask about your opinion on the cake case because that happened most recently. So I want to ask you, do you believe that's prohibiting your freedom of speech, or do you believe that they have that right based upon their religion?
Before I answer that question, since the first two questions came from students at School Without Walls, I just want to tell you that a young woman who clerked for me a few years ago went to the School Without Walls. She clerked for me, then she clerked on the Supreme Court of the United States, and Sunday night she was interviewed on C-SPAN, and you can all go watch that. It's an extraordinary interview. Her name is Tiffany Wright, and she's a graduate of the School Without Walls, and you should go watch that. You want to answer the question? It's about KKK?
Masterpiece cake? I'm glad you're thinking about the masterpiece cake case. That's pretty interesting, isn't it? Yes, it's good you're paying attention. So, judges, do you have an opinion about that?
Yeah, see, that's a case that's pending in the Supreme Court right now. And, I mean, obviously, the three of us have our views about it, but number one, our current views about it are irrelevant to what the Supreme Court decides. And number two, we really can't talk about that case now. Now, we could certainly talk about, I mean, suppose, for example, students in a school wanted to wear or demonstrate in the school in favor of one side or the other the day before the Supreme Court heard the case. Now that would be governed by Tinker, that question, because the question then would be, are the students expressing their views about this case and the issue before the court in a way that's not disruptive to the schools? That would be the issue. But
again, it's very, very fact-specific in a lot of these situations because there is the issue, as expressed by the justice that I was playing, of the disruption to the school and the extent to which school officials have the authority or should have the authority to make sure that students are learning and not having their attention diverted to other issues, whatever those issues are. So you really would have to look at the specifics. I mean, obviously, Masterpiece Theater, the cake case is not in the context of a school, and so there are different considerations in that situation as well.
All right, my name is Antonio, and I go to, my last name? Okay. And I go to Kip. I got a question for Ms. Tinker. After the court case,
I'm sorry.
After the court case, all of that, did you ever think about wearing the band again, the little black band?
Do I ever think about wearing a black armband again?
Yeah, after the court case, after you did all that.
Yes, I did wear a black armband when Trayvon was killed, and I feel like wearing a black armband quite often for things that are going on in our city and in our world. And yes, there are things that make me feel like doing that again. Are there things you're speaking up about? I have to ask you back now.
Nah, I'm good.
Yes. It's like, I have to think.
why don't we take two more questions? Any more? Are there no more questions?
Yes, Strickland, and I'm from Capital City Public Charter School. And my main question was more towards the judge that chose to dissent, because I found it very interesting that that judge said that the student expression in that case, like if it were to be allowed in a wide variety, that it would cause more disruption than if it were like controlled as it was. But in my experience, and like I'm sure a lot more experience of other students around, that when students often express themselves more when they're limited in their expression. And so that a lot more comes out of like when students are limited in how they can express themselves. So I just found that interesting, personally.
I think that's a good observation. One of the things that I found interesting about this justice's opinion was that, and this was Justice Black, by the way, I think he really focused on the degree in which the students were breaking the rule. So it wasn't so much the substance of the speech, or if the school had allowed students to speak, then I don't know that he would have been so upset about it. But it seemed as though the thrust was, there's a rule that the school officials and the school administrators have put forward. They've told you not to do this. And who is the Constitution to say that you have a right to do this in the context of the school, because it is the administrator's position. I think the point that you put forward is a good one, because I think you're questioning the school officials' justifications. Like, why would they have this rule, I think you're saying, because if you have a rule like that, you're actually encouraging more disruption than letting the students do what they want. And I think that's a fair point.
By the way, can I just add that we have a tradition in our country, it's called civil disobedience. And that's probably the hardest part to explain about my actions, was there was a rule in school and you broke it. So the thing is, for you to have a rule that you break, it should be something you feel very, very, very strongly about, a moral issue. It has to be, your action has to be peaceful. Can't just go out and do something violent if you disagree with something. And you have to be willing to take the consequences. So we had all of those three things. For example, a walkout in school, Anybody have walkout? You have to be it had something you feel strongly about, something that's peaceful, and something that you're willing to take the consequences. Does that make sense?
Last question.
I go to HD Wilson, and like we established that is limits on students and their freedom of speech. Do you believe that teachers have a limit on their freedom of speech too? Because we didn't actually talk about what happened with the teacher.
Glad you brought that up, because actually teachers' rights and students' rights are very much connected. When it's a good time for students' rights, it's usually a good time for teachers' rights. When it's a bad time for students' rights, like now, it's usually a bad time for teachers' rights. And that's a whole other area that we could talk about, all of you teachers. There have been articles written about, American University Law Journal just had a whole article about that not too long ago, the connection to teachers' rights and students' rights. And yes, it is very much connected. In this Tinker ruling, it says that neither students or teachers leave their constitutional rights at the schoolhouse gate.
Well, thank you. Let me, first of all, I want to thank Mary Beth Tinker for joining us today. It was just
Thank you all.
extraordinary.
Thank you very much. My
to
honor.
Have you.
I was honored to be here. Thank you all so much.
Tinker versus Des Moines was just a title of a case to us. Now it's a real human being. So thank you for being here. Thank you all. I hope you've enjoyed this. I renew my invitation to all of you to come see us in real. It's lots of fun. So we will, I'll ask our court clerk to call an adjournment. Thank you.